Okay. Well, we're back on this matter again. I guess I've read through all of the motions and the answers again, and at least Lisa's exhibits, because we've got those ahead of time. Ms. Thomas, we didn't get yours until late yesterday, and I didn't get them until about 8:10 this morning, so I haven't had a chance to look at those, but I will obviously before we conclude.
And I have to admit, I added a couple more this morning that I was in trial all day yesterday with referee Snyder, and I realized a couple were missed by my assistant. But they're pretty easy.
Well, okay. Well, easy unless you don't get a chance to look at them.
So can I ask, Lisa, did you email those to me?
I did.
Okay, then we'll have to obviously.
It's your client's verified statement and 1 page of a transcript.
Okay, Ms. McNiff, do you wish to make any opening statement at this time?
I don't, Your Honor.
Okay. Ms. Thomas?
I'm going to reserve first.
Okay. Any, did you want to present any proofs, Ms. McNiff, or simply argue, or how did you want to?
I prefer just to argue, Your Honor. I think there's been so many proofs in this case. I don't know that the court needs to hear any more testimony.
Okay.
It was helpful, and I appreciate the fact that Ms. Thomas provided a copy of the updated property chart. And I would first state by saying that with regard to the real estate, we believe that those values comply with the court's order. With regard to the vehicles and the boats, we believe that that complies with the court's order. We agree with the value for the storage. We agree with Mr. Miller's, the first 3 of his bank accounts. What we have an issue with, as the court knows, is the Consumer's Credit Union account. One of the exhibits I sent this morning, and I apologize, was Mr. Miller's verified financial disclosure that showed that on 12/27, he opened an account with Consumers Credit Union, and that account had in it $6,240.02. I also attached a copy of his testimony regarding that account that indicated that he thought he opened that account in January, not in December, in spite of the verified financial disclosure saying December. And that we've never had a copy of a bank statement that would indicate either the $6,240.02 or the $2,728.22. If defendants could provide us a copy of a bank statement that shows that amount on that date, we would accept it. We've just never, ever received a bank statement from that Consumer's Credit Union account. All we have is Mr. Miller's verified financial disclosure that indicates $6,200 and some dollars. So I think that's an easy fix.
I just want to interrupt really quick. If Ms. McNiff is going to be talking about a verified financial statement that apparently neither you nor I have looked at, can we take a second so both of us can grab, at least so that we have, I don't even have it in front of me because I don't have that ability in this room. Can I just go run and grab that real quick so we can at least look to see what she's talking about? It's going to be a lot easier, I think.
Sure.
Oh, go ahead.
Okay, perfect. Thanks.
Okay, good.
So that's my entire argument with regard to that Consumer's Credit Union account. I'm just asking for a statement that supports the $2,728.22 figure, or I'm asking the court to use the only other documented number that has been provided at this point.
Okay, so just clarify for me, Ms. McNiff, if you could. I'm looking at your motion for relief that was filed on 3/31, and my recollection in that motion, you don't mention anything about this account. Am I correct in that?
That is, I believe, accurate. I thought that was an issue that I had brought up previously.
I'm not aware of that.
Okay, so the court will not be entertaining that?
No, my thought was today that we were addressing the issue concerning the retirements. And that was my understanding.
Oh, and only the retirements, only the post fraction? That's
what I thought we were addressing today.
Okay.
Your Honor, I thought we were addressing both the retirements and the FSA account.
Yeah, well, yes, correct.
Okay,
Because it's not a retirement. Okay.
Right.
And just for clarification, just because I want it to be upfront and whatever, Ms. McNiff indicates that as of the, with regard to the consumer's account, it shows on his fifth form that it's as of 1/10 of 22, which is not the date that the division was anyway. And our position is he deposited it in between, like the very first part of January. So I believe that does conform, just because I just want to be open.
Okay.
we've just never received a bank statement that indicates that, and so it's a significant difference. If we could receive a bank statement, that would be so helpful.
Well, maybe you can do that, Ms. Thomas, because the court, again, it's not the subject of the motion. It wasn't the subject of this hearing. And as a result, I'm not going to address it. So you can provide documentation to Ms. McNiff, and then hopefully that will resolve that issue. If it doesn't, you can bring it back in.
Well, then I'll just move on very quickly to I think what is the easiest one, which is the FSA account. I've provided to the court the transcript where my client testified that she believes she had about $200 left in that account at the end of 2021. I've provided documentation that from KCCU that Ms. Thomas has had, and I believe Ms. Thomas in her Exhibit B actually shows that the amount at the end of 2021 was $227.36. The Blue Cross statement also shows that the balance at the end of 2021 was $227.36. And I'm sure the court understands the way this FSA works is money is deposited for the purpose of using it for uninsured medical expenses. It's a small amount because it doesn't roll over like an HSA does. It's a use it or lose it type of account that people use. And with 4 family members, it would make sense that would be used up by the end of the year. I don't know what else to present to the court other than my client's testimony and the documents that show at the end of 2021 on that date, there was $227.36 left. The court can see from the documents, it shows like 1,900 and some that is deposited at the beginning of the year. And then it shows the deductions, which are over 1,700, which then leaves a balance of the $227.36. So we would ask the court to use that number for the FSA amount.
Okay.
Then do you want me to continue, or do you want Ms. Thomas to?
Let me ask Ms. Thomas, do you prefer to address that now or all at once when you argue?
I think that because the FSA is a separate entity, I think it's better probably to address it now. And then when we get into the other, we can talk about more stuff. Our concern is on our Exhibit B, which it's notable. And the reason that we did the subpoena and included that as part of our exhibit, does Judge, you have those, right?
Yes. Okay.
The reason we included the copy of the subpoena is we had sent the first subpoena, did not receive anything about the HSA/FSA account at all.
I think it's
Thomas,
because
I'm not concerned about what you first received. I'm concerned whether it's accurate or not.
Well, okay. But the idea though, I guess my point is that, so we did a second subpoena that stuff was due in April. We got it April 28th. It was due April 6th. And when we got that, we received what I attached. And that was the email from Ms. Miller to Ms. McNiff. And on the, I think it's the next to last page of that statement, it shows the year-to-date balance is $227.36, but the coverage start is 1/1/21. So the interpretation is that that's how much was there on 1/1/21. In addition, if the court looks at the actual objection that Ms. McNiff had with regard to her motion for relief about that, the Exhibit A that she provided was in fact a little bit more expansive than this exhibit, one that she had given us prior to trial, but certainly not expansive enough. We've already specifically looked at these particular exhibits with the court prior to this. What was kind of shocking to me, quite frankly, is that we now receive an exhibit that we just received, we've never seen in trial before, that all of a sudden now we see on page 2 of their Exhibit 1, we now say we've never seen anything with this $1,732.54 ever before. That wasn't what was attached to her initial objection or concern about the FSA account. That was never a number. And what's interesting is it shows on And on the next page, it shows coverage end as of 12/29. It shows coverage end and it's zeros. These were never provided to us before. We never received a Blue Cross statement before. We never received any of these documents before. And now all of a sudden, when we're going to specifically talk about this, we have new documents that we've never seen, have never been provided from a place where the opposing party is the CEO of the company. We just find that very concerning, particularly when the documents we've used from the beginning up until now were the ones that Ms. McNiff had provided previously and were attached to her actual objection to the entry of another order, including and was discussed also including with regard to her objection with regards to our qualified domestic relations order because the number was wrong. Again, all because of this. And how do you manufacture this document now when we've never had access to it before? And now all of a sudden it's like, oh, well, here's our proof. It's like that.
Ms. Thomas, how long have you had your Exhibit B? Because I'm looking at that now. You've had that, have you not?
We have. Yep, we have.
If you look at I'd say the very end page or one before it says coverage ends, there's a page that shows the plan balance at 2/27/36.
With a date of 1/1/21, and that's not the date we're looking at. Your Honor, my assumption, it's just an assumption, is they fund this plan at the beginning of the year.
Well,
but my guess is because it's 1/1, it's a banking holiday. It probably doesn't get funded until the next business day. So
the document that we've used up until this point is, if we look at Ms. McNiff's motion for relief from the judgment,
okay,
that's the document in its Exhibit A. And we argued this the last time we were here. I believe it's on page 7, and that's just because I remember that was the page that we were on. It shows, and again, this is the same, it's part of the same documentation, obviously, from the way it's set up. So actually, if we look at, hang on, oops, I think it's page 4 of that document. It shows, nope, it's page 5 of that document. It shows the coverage start of 1/1/21, which is the beginning of the year of the date that the court ordered it to be 12/29 of 21. But if on page 7, it shows plan balance of 1999.90, year-to-date balance 1999.90. That's the number that we used.
Where is that again?
It's on page 7 of her Exhibit A. That's where I got the number. I didn't pull the number out of air. That's where I got the number.
Well, they've been using the higher number since well before my motion for relief.
Right. But we've always, because we had this document that was provided, and we've always used that number. It's never changed. We've always used that number. And I guess the thing of it is to now all of a sudden have additional documents is concerning, but even more so, a couple of our exhibits were added just simply to the fact that, this court ordered child support as of the end of December, and then upon motion of counsel at the finding, moved it to January 10th when the party moved, when Mr. Miller moved from the home, so that plaintiff didn't have to start paying child support at the same date. Now all of a sudden we have that date on this one, but now we want December 29th. He was still living there. If they're all living as a family, how can it apply to one and not the other? Why would we not take the 1/10/22 date? It makes no sense. It's like whatever's to the advantage of Ms. Miller is what they're asking for. And I certainly understand that because Ms. McNiff is required to represent her client's interests. I get that. But what we were provided up until now, the entire time, was this attachment A from, or Exhibit A from Ms. McNiff's objection. And that's what I went from. I went from their information, their exhibit.
Okay. Anything else, Ms. McNiff?
No, Your Honor.
Okay. Well, what I'm going to do is obviously there's additional exhibits attached. Those exhibits, again, were not available at trial. There's other, again, exhibits that were submitted. Those were what the court utilized at that particular time, as well as the testimony. And obviously, I would say that over the period of this trial, there was a lot of conflicting testimony in this matter, and the court, is troubled by the fact that, again, we have attempted to get this correct as opposed to get it expedited resolution. But it does appear that the exhibits previously exchanged in this matter did again show a balance of, well, there were two numbers. There was the 1979.90, and then I think there was a 1999.90 on other exhibits. And that is what the court utilized at the time of trial. The court is going to remain with that number, as that's what appears to be the number that the parties had submitted at the time of trial. And that's the only thing that the court can utilize as it relates to making a determination and finding this matter. So the court will affirm that use of that number, notwithstanding subsequent documents and subsequent, I guess, explanation. So, Ms. McNiff, you can go on to the covenanture.
Thank you, Your Honor. In our Exhibit 3, which is page 171 of the transcript from one of the days of trial, both Ms. Thomas and Mr. Miller at that point acknowledged that Ms. Miller had 401k funds that started out at Omni. And what we have asked is that the coverture fraction be applied using her start date at Omni Credit Union, because she accumulated 401k funds in her credit union National Association 401k there, which was compatible with her 401k at Kellogg Community Credit Union and rolled over. It appears Attorney Thomas has at first only used the coverture fraction with the start date of service for Kellogg Community Credit Union, and then was inclined to, I believe, carve out the premarital portion, or carve out the premarital portion, including both the Omni and the KCCU premarital portions, which it simply isn't accurate. We don't have the number for how much my client accumulated during her tenure at Omni, because she worked at Omni from 1986 until 1993, and there simply aren't records back to 1993. However, there has been an acknowledgement by the other side that she did in fact work there, that she does have premarital funds from Omni that were included in her KCCU 401k. The court did order a coverture fraction, and generally the purpose of a coverture fraction is to take into account all premarital funds in a particular account. And it also allows the accounting for any increase in the principal, any passive increase in that principal that was accumulated prior to the marriage. So we're simply asking the court to take note of the fact that there was an acknowledgement that my client had 401k funds, that they were rolled over to KCCU, and to apply the coverture fraction using her start date at Omni Credit Union.
There's no dispute on that, Ms. McNiff. Obviously, I went through the transcripts you referenced as exhibits. I remember the ruling in this matter. I just trying to, I guess you do the application of that. And I see on paragraph of your motion, paragraph 28, you said defendant's covenanture fraction omits 80 months that plaintiff had with Omni. And then you reference exhibit C. So I guess some of our issues, and I've had this in other cases where you can't get documents, so we can't say, okay, it was X amount of dollars, which obviously creates some difficulty. So what you're saying, because quite frankly, is we should do that and utilize the additional 80 months that she was with Omni. And then that would bring us to, again, the number that she had with KFCU.
That's correct, Your Honor. And her start date with Omni was June 1986. And I believe that Ms. Thomas had that date.
Okay. The only issue I take with that, maybe you can correct me, Ms. McNiff, is that we obviously don't know contribution rates. We don't know contribution amounts. And just because we use the months, that may skew the actual balances if we don't know what the rates were.
I understand that, Your Honor, but going back to the 1980s is virtually impossible.
I understand. I'm just, that's my query here, that I'm saying, darned if you do, darned if you don't. If you do, then there's a potential for other error as well. But okay, thanks. Anything else?
No, Your Honor.
Ms. Thomas, you obviously acknowledge and you recognize that Ms. Miller did work that 80 months with Omni. And again, if you omit those particular months in the Coventry fraction, then aren't we effectively not giving her credit for that?
Absolutely not, Your Honor, because we have also the dates that she we know how much she had in that account at the time of the marriage. And our understanding was that together was initially, and what we believed all along, quite frankly, having no idea about the coverage fraction. And I have distinct argument that I'd like to make about that. But anyway, our understanding was
how much did she have in that account? Then you're saying you knew how much
the 46,000 that was in KCCU. Our understanding was she had rolled some from Omni, the rest was from KCCU, but she could not break it down into an individual. This is how much was Omni. This is how much was KCCU. So that's no different than Mr. Miller's Baird account that it was his personally initially. And then he didn't close it and change it. He added Ms. Miller. We didn't know how much, we couldn't show because their Baird's records don't go back that far. So it became all marital. So we understood that because yes, those accounts were combined, but as of the date of marriage, we did have a number. So our understanding in on the property chart where it shows, frankly, that the court used throughout the trial, it shows that we understood that there were X amount of dollars that were taken out, and I believe it's our exhibit D or E. The same exact statement that we've looked at before that was provided by the plaintiff is that on the date of marriage, and this is the April 22nd period, April 22nd, 2001 period end date. She in fact had in her Omni account $16,686.96. That was then rolled over into Baird, and we're not her separate Baird account. We're not disputing that. On the next page, the next exhibit, it shows in there how much is in her KCCU 401k plan. And we see that in that 401k plan on that date is $46,836.34. So if in fact this represents the Omni as has been contended, then she didn't have a KCC plan because this is her total plan amount. So if this is all Omni, then this isn't KCC, and the entire KCCU one is all marital. If this is Omni and KCCU and they can't define it separately, then this is how much, and it's assumed to have been earned during KCCU because she kept her Omni one separate. So, but we can't do it both ways. Okay,
hold on. Let me ask Ms. McNiff. Ms. McNiff, do you acknowledge that again at that date, which would have been right around the date of marriage, that she had in the account the $46,836.34?
We do, but we don't believe that a carve out of that exact amount makes any sense or is reasonable for the reason that those funds were invested and they were receiving interest and dividends. And even, over that period of time, at basic inflation adjusted, that money would be worth at least $125,000. And it could be worth as much as $200,000.
But that was the balance at that time, correct?
Correct. We agree with that.
Okay. So that was the balance of the Omni at that particular time.
Correct. And I think if there's going to be a carve out, there should also be an adjustment for increases and decreases for that period of time.
Well, at least we have that, which I guess puts us ahead of where we were previously, because we have a number showing what was in that account at that particular time. Okay, Ms. Thomas, go ahead. I just wanted to see if we had confirmation of that.
No, that's fine, Your Honor. And based upon that, my true argument in this case is that, and again, I'm just gonna do kind of my argument overall as to this whole issue about the accounts. Marriage is a status that legally terminates only upon death of a spouse or the entry of a judgment, according to Kurtz v. Kurtz, and that's 178 Mich. Act 284, 291. There is no de facto divorce in Michigan jurisprudence does not recognize consensual divorce. Michigan law provides that it's from the time of marriage to the time of divorce, and including the requirement to make a divorce effectual, which means that this divorce didn't happen until well, actually, because of numerous issues with the judgment of divorce, this divorce didn't happen until March 27th of 2023. And that was all during the marriage. By excluding from consideration plaintiff's split dollar KCCU compensation package to Pacific Life and Penn Mutual, which vested after the filing of the divorce, but significantly prior to the trial, caused by, through no small part, frankly, delays at the hands of the plaintiff, this court has already divested itself by ordering post-marital increases in a premarital asset, which has been commingled with marital property, and that there's no ability to identify. Because and that's fine. That's what the court ordered. That's fine. But this alleged further transfer of premarital contributions from Omni into another premarital asset, and then allowing the asset to be credited with another premarital asset, and then adding those months together and doing a coverture fraction, is frankly double dipping, because you're giving the benefit of carving out that amount and the number of months taken that it was earned. And we don't even know for sure how many months of that KCC one was earned. The court's already ruled on part of this. The court's already ruled that the money that was just Omni is Omni. The court already ruled that we're not putting Omni into the KCCU, and the court's already ruled on those two issues. So, which is a little concerning to me that we're even here, because that's already been argued. What my bigger concern is that we know at this point, we knew at trial, we knew now, we've always known that in the plaintiff's account, she had money at KCCU that, in fact, $46,000 of it was premarital. In addition to that, we knew that the Omni money that showed on the exhibit we just looked at was rolled over into the separate Baird account that's just in Ms. Miller's name. Everyone's agreed on that since the beginning. There's no property charge. There's no anything from Ms. McNiff that shows anything other than that. But as to the coverture fraction, frankly, while it's necessarily used in cases where there's no clear way to make a determination as to premarital versus marital, such as pensions, railroad retirements, things like that, I mean, there's no way to know. But in a situation, where it's not a defined benefit plan, it's actually a defined contribution plan, we do know. We know now, we knew then, we've always known. And to choose a valuation date, obviously 15 months before when the divorce finalized, and then divide that down with a defined contribution down by a coverture fraction, it makes no sense. We have the numbers. Although Ms. McNiff appears to be arguing that any attrition or increase in that should be separated out, that's not what the cases represent at all. We're 4 months past now the finding in this matter. We're still at odds with the court ruling. It's an easy fix, and the easy fix is what was there before the marriage is premarital, and everything else is marital. That's the way that it should be, and that's the way. I mean, anything that's earned during the marriage, and that's from the time of marriage until the time of divorce, which we're still, we were all the way up until March 27th, still married. That is all considered marital. The case law is frankly quite clear, as stated in McNamara v. Horner, who was relying a little bit on the Reeves case, and they say that that's inappropriate because the increase in value of the accounts is not wholly passive, when in fact the parties are continuing to contribute to those accounts. Because they're continuing to contribute to those retirement accounts, it's not passive. Therefore, that's not to be. McNamara is very on point in this. The court's chosen method of substantially altering from that significant way that is evaluated. From the property chart again that the court used, it showed on there these two accounts marked out as they were premarital, and that we weren't including them as a marital asset. To now do them by coverture fraction and take into account months we can't tell what's what. When we do have numbers, we have accurate numbers, we have absolute numbers. We've always had these absolute numbers. Makes no sense. I think that we've already strayed a bit because, again, the Penn Mutual one did vest during the time of the divorce. The parties are still married. They were both investing. They were investing in their 401k. Mr. Miller has his premarital SEP. They were continuing to invest in these accounts. And so, frankly, it's commingled with marital. We're fine with taking out the part that's premarital, but any increase in those happened during the marriage. And if it happened during the marriage, it's marital. Case law is very clear on this, and we're asking the court to consider that and consider case law because, frankly, this is it's a huge difference in this case. We're talking $250,000 in this case. It's huge, and to think that, well, we should take a coverture fraction of a contribution plan versus just a defined benefit plan that we can't determine is not realistic when in fact the increases in value of that account, whatever Ms. Miller had in there, happened during the marriage. As to her Omni account that was rolled over into her separate Baird account, we understand it was always separate. It was always apart. It should be hers. We've always considered it just hers. However, when we're considering an account, an amount of money that she had, she continues to invest into that every month, actually every pay period, I believe, a significant amount of money. And that's hasn't come home to the marital estate. It's been put in there, and it's a significant amount. And to believe that should be what it's commingled, it's added to during the marriage, to believe that you can take what Ms. Miller makes today, what her earnings are today, and the amount of her percentage that she's able to put into that today, and compare that to what she made, what little she might have made at Omni in comparison, or even early days at KCCU in comparison. We know that she worked at KCCU. We have a start date of when she worked. And as of, even with the Omni rolled into it, she only had $46,000 in 2001. And to now, all of a sudden, we're giving all of the benefit of all of these years to that account and counting as that all months are equal, when clearly she didn't make $360,000 or $80,000 back then. And her percentages are certainly drastically different. So I just believe that doing this as a coverture fraction at all is inappropriate and not in line with what a reasonable person would assume, for one thing. But beyond that, it doesn't conform with McNamara at all. And because we're still arguing about it and we still don't have an agreement on it, I think there is a solution. And the solution is for both parties, how much do they have at the time of when the marriage was? That's theirs premarital. Anything over and above that to what it was at the valuation date of the court is marital. Whatever valuation date the court used, in this case 12/7 of 21, from whatever was earned from April 2001 until December 7th of 2021, that is marital, no matter what. And then the basis of it, you're getting what you had when you came into the marriage. And then anything else you did and you added to it, you increase that with marital money. It's a commingled asset anyway, but we understand premarital, and it's accepted that way. It's done that way all the time. However, to use a coverture fraction when we have the numbers, and then ask to double dip and have that carved out. And even though we don't know how much of that time that is Kellogg time and how much of it is Omni time, we're asking for a double dip and maybe even a triple dip on this one, because we've already set aside the Baird account as Ms. Miller's separate account. So she's already gotten that part of her Omni money. If in fact Omni money is put in here too, she's already gotten that part. So to also give her credit for the months of a portion of the Omni account in a coverture fraction is highly unequitable for Mr. Miller. And that would be wrong. So we're simply asking that the court, we have the numbers. She's already got her Baird account, which is part of her Omni. We have the number of how much Omni was at the time of marriage. We have the number of how much Kellogg was at the time of marriage. Frankly, we have the number as to how much that Mr. Miller had in what is now the Wells Fargo was, I believe at that time, Prudential account. We have all those numbers. Take the number as it was as of the date of valuation, subtract the number that they had before. They continue to contribute in both of those accounts during the marriage, and be done. And we can be over the whole argument.
Okay, thank you.
Your Honor, can I briefly respond?
Go ahead.
Your Honor, the court has been adhering very strictly to its original finding. And it sounds to me like Attorney Thomas is requesting this court overturn its decision regarding the coverture fraction. The court ordered that the coverture fractions be applied to both parties' retirement accounts, which is fair and reasonable. But to cherry pick and say only one account won't be subjected to a coverture fraction is completely unreasonable. Yeah, I agree that it's quite a bit of money. However, if you look at $46,000 indexed in 1986 to the S&P 500, you get about $200,000 that would have grown over that period of time. That's the whole point of a coverture fraction. The court understands that. That's why the court ordered that all of the retirement accounts be subjected to the use of a coverture fraction. So we would ask that the court simply do what it's been doing with all of its other decisions and maintain the finding that the court issued originally. Okay,
thank you. Well, in this matter, obviously, as the other issue, there's extreme confusion in this particular matter based upon, again, a number of things, where the funds were from Omni apparently rolled into the Baird. That was kept separate, so there's no dispute on that, and those were to be excluded. Obviously, the defendant's account we were not able to exclude because he was not able to identify any amounts, and that was all commingled. We do have a lot of issues of commingling in this particular case. It's been alleged by Ms. McNiff that we need to look at, again, the growth of these particular funds, but again, that's speculative as to, again, what was the growth amount? We don't know what that is. The issue is, both parties, I think, would acknowledge that they made different money at the start of their marriage than they're making, let's say, in the last few years. So if we count each month equally, that does in fact present an inequitable result as well in this particular matter. There's no doubt the court used a valuation date of 12/7/2021, and then we have the marriage date, and that was the purpose of the court using a covenanture factor would utilize those dates from the date of the marriage to the valuation date for purposes of determining the marital portion of those accounts. I haven't heard anything today that's going to change the court's ruling in that particular matter. I will continue to use the date of marriage through the 12/7/21 date. And I'm not going to speculate as to what the growth was from different amount of monies that were essentially commingled and put into a marital asset, because you would never end. I mean, that would be you would be speculating forever as to what it was, because there's no way to do that. And as a result, that's how the court is going to rule in this matter, that will remain using that particular covenanture factor, and that's going to be the ruling of the court. So that will end the matter.
Your Honor, can we ask questions?
Yeah,
Okay, because that's what you ruled before.
that's.
And
I was
question.
hoping that you'd take it as that's how I ruled before.
Right. And that is what you ruled before, and that's fine. But whether we agree or not is immaterial. That's what you ruled before. There still came the question. And so, because I just want this to be done and have a final order and move on, stopping the bleed for everybody, quite frankly, including the kids. So because we don't know how much of that premarital was Omni and how much was not, when we had divided it, we had used KCCU as KCCU for the date, given them the whole time, even though like that she worked at KCCU, because we've already given them Baird for the Omni months. So if we use the number of months that she worked at Omni added to this, she's getting money for Baird as well as Omni. So the question I have is to just make sure. My understanding is that as to the Omni that went to Baird, that's her sole and separate.
There's no dispute on that.
As to the money that was combined with KCCU, we can't delineate it differently. So we're going to use it from start of time when KCCU started until the marriage date between. And it starts with her start date at KCCU. That's the real question. Does it start at her start date at KCCU? Because that's where the account is.
Well, no, we wouldn't use her start date because that's not the marital. Use the marital date as the start date.
Right, but the marital portion is the numerator in a covenantal fraction. The denominator would be her start date in order to give her credit for that start date.
Right, because she would be getting credit then for the pre-marital portion.
Right.
That
so
was
the denominator is the start date at KCCU, correct?
I don't understand at all.
Okay. Well, what she's saying is correct. Is if we're using as the numerator would be the date effectively would be the date of marriage. The denominator is the date that she started at KCCU.
So it's the months of the marriage and the months of service. It's not the date, it's the months.
Right, yes, but you utilize the date.
Okay, so we've got the months of marriage, and then for the months of service, what are we using?
Her total months of service, the time at KFCU.
Only at Kellogg Community Credit.
Correct.
Even though that includes Omni funds.
Well, the Omni obviously went into the Baird account, which was a separate account, and we don't know what the amount of the Omni funds were.
We don't know the amount of the Omni funds, but we do have a clear acknowledgement in the transcript that Omni funds from Mr. Miller, that Omni funds were.
But we don't know, and I'm saying I'm not going to speculate as to what's in there. We're utilizing as the numerator again the time when the date of the marriage, however those months are, and the denominator being the total months at KFCU, and that gives us the covenanture fraction because that divides that particular account.
So she loses essentially all of the funds that she rolled over from Omni.
No, because the funds she rolled over from Omni went into the Baird account, and that's a separate account.
Some of them did, but there were two Omni accounts. One acknowledged completely went into the Baird account, And like I said, in the transcript, Mr. Miller acknowledged that there were funds from Omni that were,
But again, I guess what I'm going back
went
to,
into the KCCU 401k.
and it's no different than Mr. Miller's account when we had no idea what went into from the Wells Fargo into the account that he rolled over and commingled. There's no way of knowing what those funds are, just as there is in this. There's no way of knowing what those funds are. I'm not going to speculate as to what the funds are. I'm not going to put a dollar amount on what the funds are because we don't know. And so when the parties don't have that information and don't present that information to the court, I can't speculate as to what that is. And unfortunately, that may result in some, I guess you say, a disadvantage to a particular party, but I'm trying to do the best we can with the information that we have. And that's how I'm going to resolve it with that fraction. So Ms. Thomas, you can prepare that order, which will confirm what we've done today.
Okay, Your Honor, can we look at my exhibit I at the bottom? Because I think that's what we've already done. So I just want to make sure that just so that there's no question and no objections to an order that I prepare. I'm more than happy to do the order. I just want to look at it because I believe that that's what we've done. But if that's what we've done, then it also eliminates the objection to our quadro that's been presented to the court as well. And that could be entered as well. I want to make sure.
Okay.
I agree that this complies with what the court just said. I won't say I agree with it, but I agree that it complies.
Okay. Ms. Thomas, does that give you your answer then?
Well, it does. If in fact, then based upon that, if Ms. McNiff is also then taking away her objection to our entry of our qualified domestic relations order, and then that could actually be entered today.
Well, I think she acknowledges that Exhibit I does in fact provide and reflect the court's ruling. She basically doesn't agree with that ruling.
No, I know.
So that'll be subject to clarification or something from the Court of Appeals apparently. And
okay, so
then we'll deal with that.
Okay, so here's what I don't know then. So I noticed up the entry of our quadro. The objection to the entry of our quadro from Ms. McNiff was the same thing we just did. So
Ms.
if
McNiff,
that's
is that accurate? That again, you're objecting to the quadro, but it reflects what the court ruled.
That is accurate.
Okay, then Ms. Thomas, don't say anything else. I don't want you to argue against your position. I will enter that quadro then because it's consistent with what this court ruled, but not Ms. McNiff is not in agreement with that, but we'll have to take that to the Court of Appeals.
So there have been 2 quadros submitted to the court. I just want to make sure that so I submitted one and then Ms. McNiff objected and attached to hers was an alternate one. But frankly, because she used our first and last pages and just changed the middle, it looks like it was mine. I just want to make sure that the court enters the one that is actually ours.
Ms. Thomas, what you'll do is contact my office when we're done, talk to Christy and make sure that the correct one gets sent to me. So the problem we have effectively would have 3 different orders.
Right.
Make sure the right one gets sent to me, and that's the one that I'll enter.
And this will be a final order?
That will be a final order, correct. Okay?
Perfect. Thank you.
Thank you. The court will end this matter at 9:24 a.m.